we dealt with half of the bit that has to do with minority shareholder protection when we talked about derivative actions, which is kind of a mechanism for people in a precarious position to complain about things going wrong. And today we kind of finish this off by talking about various mechanisms that minorities can use to protect themselves, and ending up talking about the crucially significant tool, which is an unfair prejudice petition. So we start off by kind of going over a little bit about the core information on majority and minority shareholders, and then we see how these particular petitions work after we look at the series of other instruments. Obviously, people have the chance to participate in corporations at varied proportions. This is perfectly normal because not everybody wants to have the same level of commitment or to have the same level of involvement or has the financial capacity to contribute in the same way to a corporate entity. So there's absolutely nothing wrong with corporations having different numbers of shareholders or having different proportions of participation within the shareholders within the general meeting itself. One of the issues, however, is that shareholder decision making is the majority of the general meeting. General meeting gets to take important decisions about things that have to do with the running of the company. So they can decide, obviously they've got the power within them to change the articles of association, which means that they can change the framework within which the board of directors makes decisions, but also they can have important tools available to them, like getting rid of the directors themselves, for instance, or appointing new directors and all of that stuff. If this is happening in the general meeting by a majority vote, then there's always going to be somebody in a position of lesser influence if they have very few votes. This can happen even if you just got two shareholders. If one has 90% shares and the other one has got 10, then clearly the person with the 10% doesn't really get a lot of say in things. Or even if you've got large amounts of shareholders, if you're thinking about the public company listed in the stock market, it could be there are loads of shareholders, thousands of them in fact, but if there's a couple or more big groups that have 50% of the totality of the shares and everybody else just has minute percentages, then obviously the people who can control this bulk of the votes get to decide what happens with everybody else. It is the nature of the beast. I mean, you know when you're getting into a company and when you should know how this works and you've got ample opportunity to figure it out. So you are accepting that you're in a position of lesser influence. You could see it as other people doing the work and you just reaping the benefits. Because I can go right now and buy some shares in whatever corporation I want, and I'm never going to have to do anything at all, and I just wait till the end of the year to get my dividend payments if the company has done well. If the company hasn't done well, nothing bad's going to happen to me, other than perhaps having locked the amount of money I got the shares in this company for a little while longer. So it isn't the end of the world. And big corporations, most of the time, they don't go insolvent. So it wouldn't be an issue if they're not going well. Even if I have a handful of shares, it wouldn't be an issue of me losing my money. It just might mean that my money stays in there for longer than I intended originally. It's a great deal. I'm essentially free riding on somebody else's work. So it isn't like we shouldn't pity the people who are minority shareholders. They're minority shareholders for a reason. However, you do need some mechanism law to protect people who are in this minority position in case the rest of them gang up on them. Now, this usually tends to happen in smaller private limited companies where you've got a defined number of people, and it could be that the majority want to take the company in directions that you're not particularly comfortable with, or they're trying to mess with you because they decided they don't want you involved at all. So there needs to be some protection for somebody in a position of lesser influence so they're not taken advantage of. And there are a series of mechanisms built into the law to offer this protection. It balances the scales a little bit without upending the fundamental understanding, which is if you put in more money, then you get more say. One of the things that exist in the statute to protect minority shareholders, you can find in Section 25 of the Companies Act, that says you are not liable to pay money beyond your initial contribution, even if the articles are changed that mandate additional payments. There is no way that the company has the legal power to make additional payments once you become a holder. Because the key idea is you decide when you want to enter into a corporation at the point that you're entering, so you know the extent of your financial involvement. Into a corporation at the point that you're entering, so you know the extent of your financial involvement. Then the tables and make you pour in more money subsequently. One key protection. The key protection in a position of lesser influence is the idea that you need the supermajority at the meeting to effect some significant changes. Now, we can which things should majority, but at least you know altering the Articles of Association, majority of 70. So it's not a matter of majority. Articles is so significant that the law says we need to have the security of knowledge that the vast majority of people consent in doing something if that something has so significant. You could argue, therefore, that the provisions either in the Companies Act or in the Articles of Association themselves, for a supermajority to be necessary before certain things happen, you can consider this to be a significant protection for shareholders in a minority position. Another protection that we have is the idea that shareholders are equally treated. Every time something happens or something changes, the impact needs to be shared across all shareholders, and the board of directors cannot arbitrarily make decisions either to benefit or harm certain groups and not others. And rights that exist if you've got a different class of shares, for instance, that's perfectly fine. But within those classes themselves, the directors do not have the power to discriminate between one shareholder and another. If the company was issuing additional shares, for instance, they need to make these additional shares available to purchase to everybody. This is called the equal treatment rule. An example of this you can find in the listing rules for publicly listed corporations. When a public company is making more shares available, generating more shares, is increasing the share size. Of course, the minority shareholders is to have access to the courts and ask to the courts for assistance when you think that your rights are getting violated. So this is a kind of baseline protection that exists for all legal rights, and it is expressed in the context of companies and protections of company interests. It is best expressed through the tool of derivative action. If you have something that the board is doing that is inappropriate and the majority of shareholders approve of, but it remains inappropriate and you think there's some sort of scam going on, then the derivative action gives you the tool to get court assistance in order to correct that mistake. Another powerful technique that is available to shareholders is the idea of giving the minority exit rights if the court feels that their rights are violated to an extent that it is better for them that they recoup their financial interest and go someplace else. Now this is primarily done through the compensation for expropriation and stuff like that you're going to see today through unfair prejudice, but it kind of crops up in various places in the Companies Act. You should understand an exit right as a remedy. Because if somebody is complaining that something bad is happening to them, if you tell them, well, in order to compensate you, we're kicking you out, it doesn't sound very appropriate. But if you think about the shares as a financial investment, getting somebody kicked out when they're already suffering some sort of discrimination sounds weird. But if you think of shares as financial rights, if you're compensating them appropriately, so they're not losing in terms of money by getting out, the court perceives this to be an appropriate remedy. So if you kind of switch the mind frame from protecting somebody's position and expectations, you're switching it to protecting their money, then an exit right, if a minority is suffering some sort of trouble, sounds like a more legitimate way of dealing with it. Now, we've seen in a variety of areas as well that the court has powers in the common law to review decisions of the board of directors and of the shareholders to make sure that they are compatible with company interests. It isn't very common to do this, but we have seen already that even though individual shareholders are allowed to pursue their own individual interests, when the general meeting is voting on stuff, there is an overarching obligation to make decisions in the interests of the company. So this is something that the court has the right to come and review. So if individuals are allowed to do what they want, they can sell their shares if they feel like it, for instance. But we're talking about decisions to alter the articles or something else that happens in general meeting, there's an overarching obligation to do this with the interests of the company in mind. All this probably is easier to digest if you step away from a democracy analogy and thinking that the general meeting is a democracy of shares and you've got people as minorities and you need to protect them. So if you step away from this into thinking about property rights and financial interests, then perhaps it makes a little bit more sense. If we look at some case illustrations, the idea that the articles, there's a power in the general meeting to change the articles, but this power must be exercised bona fide for the benefit of the company as a whole. This is expressed in cases like Allen versus Gold Reefs of Africa, one up there from 1900. This is one of the old cases where people in a minority position brought a complaint to say these guys here are changing the articles in order to harass us or to exclude us. They're not doing it in order to promote the interests of the company. You can have a look at that as an illustration. But most usually, these types of arguments are coming in cases of the compulsory expropriation of a minority. So when the majority in the company is trying to kick somebody out. Even if you have provisions in the articles allowing the majority of the shareholders to pass an expropriation provision against the minority, as you had in the case of Brown versus British Abrasive from 1919, then this still needs to be exercised with the benefits of the company in mind. And you got a series of cases where the court is exploring this. What the court has said in cases like Sidebottom, for instance, and Shuttleworth and Cox Brothers, is that you need to have a legitimate sounding reason. So the court really is not in the mood to go and second guess particular decisions of the shareholders, and they cannot really get into a completely subjective mind frame to say, well, why were these people doing that and why they were doing it and what did they think at the time. The court does not have the capacity to sort of get in there and micromanage in that way. But the court at least needs to have some indication that whatever action has been taken in good faith. So you have a minority shareholder claiming against the company that they're trying to kick them out. Unless the majority can come up with a logical reason why they took the action, because if the court thinks that this is an action done in bad faith, then this is not an action promoting the benefit of the company, or this case law gives them the power to declare whatever action has been taken as inappropriate and to strike it out. It's a simple threshold. It's just enough for the defendant to come and say, we were trying to invite in new investors, so we understand this has negative consequences on some people, but it's part of a wider view of what we're trying to do with the company. If they manage to say that, the court's going to say, okay, fair enough. This case law is something that you need to have a look at when somebody is complaining that they're being unfairly treated, but unless you got really obvious cases of discrimination and personal animosity that expresses itself through general meeting decisions, it's unlikely that the case law on its own can provide the solution to these things. Because again, as I told you, good faith is the only test that is present in the common law to protest against expropriations, compulsory transfers, and all the rest of it. If you remember anything, or if you've come across this in earlier study, good faith isn't a particularly well-digested term in English law. I mean, it crops up all over the place, but courts are really not happy with it because it's an invitation to a very subjective analysis, and the court really does not want to be into that position. So the court prefers clear-cut rules or clear-cut things that you can determine from an objective point of view. It doesn't enjoy challenging the mentality of people when they're making decisions. What you're meant to remember from all of this is that, yes, there is within the common law some capacity for the court to review shareholder decisions, but this is weak. It is based on good faith. It is partial. Identifying a violation, like a breach of directors' duties or something else, and if the company does not wish to remedy this, then using the derivative action to pursue it, yes, that works. or if somebody has been unfairly treated, using the idea of unfair prejudice that I'm going to tell you in a moment, again, that works. Using good faith-based case law works less well. It's something to absolutely know about and to be able to use it if it comes up, but it is unlikely that in real life people are that stupid to be so upfront about negative intentions in order to mess about other people. So they usually try and hide what they're doing. Are there any other mechanisms within the articles or contractually based, for instance, that a person in a minority could use to make their position more secure? One is a tool available in Section 22 of the Companies Act, and it says that you can make certain things not capable of amendment. So you can make sections of the Articles of Association having higher majority requirements in order to change them, or you can even make them possible to change unless the entire company agrees. This is called entrenchment, that you make something subject to 100% agreement. Now, you cannot make something subject to no change at all. The rules are that the general meeting remains sovereign in that context. So if the general meeting wants to change something, they should be able to. Some things cannot be set in stone, because then the company loses the sort of dynamic elements that allow it to adjust in the future. But you can have a provision that says everybody needs to agree. Now, the problem with all of that is that you cannot entrench articles simply through a normal change to the Articles of Association. Articles that are entrenched are those that are done at the beginning, when the company is being set up. When everybody joins in, they know that some articles are entrenched, or if you want to do this subsequently, you need to get all the shareholders to agree to such entrenchment. It is a tool, yes, but it isn't something that you can easily do. And once people have started fighting, there's absolutely no way you're going to achieve 100% majority in order to entrench articles from that point onwards. It is perhaps simpler to just create different classes of shares and work with that. Different classes of shares with specific rights is the easier and more accessible and more sensible way to put some rigidity in the Articles of Association, and it's a much better technique than entrenchment, because entrenchment is just so difficult to achieve. But you can always create an additional class of shares, put some people within that additional class, and then you can tell them, look, you may not hold a high proportion of shares, so you cannot decide things for the whole company, but at least you know, since you're in a special class yourselves, we cannot mess with you unless you agree for some change to happen if it affects your class rights. Now, one final tool is the idea of shareholder agreements. The problem with shareholder agreements is that they're contractually based and they sit outside company law. Whatever happens for the company as a matter of company law is present in the Articles of Association. That's what you've got. You've got the case law, you've got the statute, and you've got the Articles of Association that determine the framework of operations of the company. It needs to be present in the Articles of Association. There's nothing to say that you cannot have separate agreements outside the company between people themselves. We can have contracts about whatever we want, whichever way we want it. Get a contract together that says if the company wishes to do something else, then you will I will compensate you, or whatever. Or we can have a contract between us that says we will vote together. So whatever I decide to do, you follow along with me. Now, why you want to do this or not, depends at the time and what they wish to do. So a shareholders agreement is possible. It's a contract, right, between individual people. If you don't respect it, then you're breaching that contract and you suffer whatever consequences may come if the other person is suffering loss as a result of your breach of contract. And it will constrain the behavior of shareholders who are subject to these agreements. But here's the trick. Shareholder agreements are between individual shareholders, so they will not bind the company. The company still. Shareholders can still vote whichever way they want at general meeting, even if they are violating some shareholder agreement. Maybe they decide to violate it and worry about getting sued later. Plus, shareholder agreements are named, so it's between specific people. If new shareholders come in, they're not bound by any pre-existing agreements. you can see shareholder agreements are a useful tool in organizing shareholder behavior, but it exists outside the domain of company law. So whatever comes from violation, they're going to be on a contractual basis. The company and the general meeting can still do whatever it was doing before. And the reason why it will not bind the company is Section 21 of the Companies Act that says that the company is not allowed to contract away its constitutional powers. So if you want to affect the way that the company makes decisions, you cannot force the company to do anything through an outside agreement. An example of this happening is in Russell. What about unfair prejudice? This is the provision that is trying to help people who are in a marginalized minority position, and in fact something's happening that is meant to harm them directly. We're not talking about people who are vaguely unhappy. We're not vaguely unhappy. We're not talking about people who are unhappy because the company is going in a direction they don't like. This is not a sense of dissatisfaction or disapproval of corporate strategy. Unfair prejudice is there to help people who are being dumped on by the majority in a targeted way. This only works statutory provisions. So this isn't something that you can, we have case illustrations to help us understand what the criteria are, but it can only work through the statute in the same way that derivative actions can only work through the statute. Every time that you have to address a problem question on these things, you have to start from the statutory provision. Otherwise, you're never going to get anywhere. Section 994, it says that a member of the company can apply to the court directly for assistance if they are arguing that the company's affairs are conducted in a manner that is unfairly prejudicial either to the members of the company in general or to them specifically. And they can protest against an actual or proposed act or omission by the company. Of course, what we need to do here is to understand what is meant as unfairly prejudicial. It's great to have the power to protest against these things, but if it's left at the level of a label, then you don't actually know what would count as unfairly prejudicial. So that's where the case law is going to come in to help you understand what it says in Section 994. This is something over and above protecting legal rights. This is a wider remedy than the stuff that we've seen people derivative actions. Because if you remember in derivative actions, there was some concrete breach of duty by the directors or some action taken beyond the power of the articles, something really specific. This is wider than this. It's not so specific. What it's interested in is protecting the legitimate expectations of the person. Legal rights, of course, if something is happening in violation of the articles and so on, that works well. But it does not have to be that. It means that for somebody who entered into a company with a specific arrangement and they've got specific expectations, if these expectations are violated in a way that is unfair, then they have the right and complain at the court and receive some sort of assistance. So remember this, is not only legal rights, is a wider array of things that comes under the banner of legitimate expectations. That explain this idea that you absolutely need to know about are the Saul Harrison case and O'Neill and Phillips. So we're not talking about expectations that in contractual form, we're not talking about expectations that derive from the statute only, but we're talking about things that arise out of a fundamental understanding between the shareholders, an understanding that has formed the basis of their association. Most of the time, the complaint is about expropriation. People are complaining that they're getting kicked out and they're being treated unfairly because the price that they're offered in order to sell their shares is not appropriate. Because you cannot obviously kick people out by destroying their shares. You cannot just say, we're canceling those shares so they don't exist anymore. What people do is that they will say, we want you out and we're willing to offer you X amount per share so we see the back of you. And the person's going to say, hang on a second, why are you valuing the shares that way? You're giving me next to nothing. These shares are ought to be worth a lot more. That's how you end up in the court. In O'Neill and Phillips, this is an example of an expropriation case, and the court is saying that the petitioner complaining would have been treated unfairly if the valuation is. It is not enough to say that it's unfair because they're trying to buy me out. That in itself is not a problem. What you want is they are offering to buy them out, but they don't have an independent way to value the shares. The valuation that's been done on the shares is completely arbitrary by the people trying to kick them out. It is not in agreement with the understanding of what these shares are worth and what these people were trying to do together. So again, you see the focus is on the value. It's not on the fact that they're getting kicked out. What upsets the court is not so much that the relationship has broken out and they want these people gone. What offends the court is that they just pull the number out of a hat, and they're not paying fair value in order to get those shares. The typical situation is what we call a quasi-partnership company. What is a quasi-partnership company? In private limited companies, there are a defined group of people that are coming together to continue a business through a corporate form. So this is the scenario that a couple of people, they've got an idea or they've got a shop and they're thinking they've already been running this as sole traders or as a partnership, and they're thinking, why not do what Solomon did, take advantage of the corporate form in the future, so both to benefit from any reputational advantages or to scale up stuff or to bring in additional investors or to use it as a way to coordinate our activities. So the company structure gives us a secure way on who does what and when and how do we distribute the profits. So it's a nice idea. Obviously, I mean, if it wasn't, you wouldn't have companies all over the place. But adopting a corporate form is a nice idea when you're scaling up a business and a business is beginning to grow, especially when it's a business that involves a lot of people working together. But the reality of the matter is that as the functioning of concerned, nothing has changed in the daily experience of the people running before they were incorporated to after they were incorporated. If you take the example of Yorgos and George and the toilet flushes, if there were two people, okay, they were working together before as partners with no particular separation of tasks, no formal separation of tasks, no formal separation of money between the business money and the personal money. They decide to incorporate. They split the shares by half. George has 50, Yorgos has 50. They become the two directors of the company. So they're the two directors, they're the two shareholders. They continue to, they've got defined roles and they've got an understanding of what all this means, and in a way that's visible to anybody from the outside. And they get the money because they also hired themselves as employees, but they also distribute the profits through the shares at the end of the year when that's possible. It's great. They decide to issue some additional shares or to sell some of their shares to a third person because they need some fresh money in order to expand the business. So they get a third person in. So now there are three. Again, things haven't really changed for them, right? Yorgos and George are still the people running the show. Shareholder who is like an investor that decided to put the money in through the shares. They're all getting along nicely. And then at some point, they get into an argument because Yorgos and the new investor wants to do something and take the company online, for instance, or whatever. But George is more traditional and he thinks this is too risky and wants to keep it the way it was done. Because arguing with each other, the relationship degrades. And at some point, because now Yorgos and the external guy together, they've got more shares than George, they decide to kick him out. At general meeting, they vote him off the board. So he loses his position and he's left as a shareholder. He's very frustrated because he no longer has any participation in decision making. When it comes to voting at general meeting, he's always outvoted because if he's got something like a third of the shares, the guys who've got 2/3 of the shares can always outvote him. Maybe they don't have enough in order to change the articles, but so far as everything else is concerned, the guy has got no say anymore. So they come at some point, we're unhappy with you, why don't you pack your bags and go? And he's thinking, okay, what's the point of sticking around? I mean, there are options here because sometimes people say, no, it's my company, you're not kicking me out of my company, you go. But assuming that he accepts, and they say, we're going to pay X amount of money for your shares, we're going to give you back what you put in initially. And George goes, your shares, we're going to give you back what you put in initially. And George goes, I've been working here for years, right? We built this company up to something significant. You can't give me now back when When we started, we were in a shed, and now we've got like an entire building, and you're gonna price me the same way as it is when I came in? No, I'm not having that. That's how they end up at the court. Actions are taken by the company that marginalize his position even further, or they alter the articles of association in order to compulsorily acquire his shares, or they try to do kind of share buyback and to absorb him in. All of these things are of questionable legality because there are specific tools that you need to use and ways in which to do them. All things, they start misbehaving, not respecting the articles and completely ignoring decision-making structures. So the whole thing goes. George is the kind of guy who is usually the case study for an unfair prejudice petition. But what is his complaint? The complaint is not simply that he's getting investment, and it's not that they've engaged in certain violations in the way that they did stuff. The argument is broader. The thing is that his legitimate expectations are not being met. And his legitimate expectations were not work for this business, were not have shares in this business. The legitimate expectations were that he is involved in the management and the future and the growth of this business. So he has a multi-layered involvement that he expected this to be his baby, his job, his business, right? And to grow with it in the future. And he does not have that anymore. The basis of the complaint is, of course, understand what are the requirements in 994, right? So what is the statutory structure for unfair prejudice? But then you need to use the case law and to use these various examples to understand what do we mean by unfair prejudice. Okay, we've got a system that allows us to get some remedy for a person in a minority position, but what does it actually mean to have behavior that is unfairly prejudicial? And if this rests upon the protection of legitimate expectations, what counts as a legitimate expectation? And once you've worked your way through that, then you can get to the bottom bit that says, all right, so we figured this out, now what? The problem is that the usual remedy for unfair prejudice is exit. But exit at an independently determined price that actually reflects the value of the relationship. That might strike you as bizarre because, as I said at the beginning, because they think that their business has been taken away from. What you get as a remedy of the court is an exit. It seems counterintuitive, but the exit is going to be at a price that reflects the involvement and the expectations and the actual value of what this person is living, not a price that's determined by the arbitrary determination of people who hate him and want him gone. You might need to have a look at other mechanisms as well of protection. So that's why you have at the beginning of this lecture all these other things that might be open to a person in a minority position, and then you end up with unfair prejudice. So this is a whole array of tools, if you want. You get the various kind of common law developed techniques, then you've got derivative actions, then you've got unfair prejudice. So it's something that kind of spans 2 or 3 lectures here, but it is all stuff that if you are in the domain of minority shareholder protection, these are all things that you need to know and to be able to use. Somebody who comes and says, hey, I'm the little guy and I'm suffering because they're doing